Good afternoon, everybody. This is the last panel of this conference. And am I speaking well enough into the mic? Okay. This has been such an incredible panel that I feel that there is a lot of pressure on our panel to say something brilliant to bring it all together. But I also feel like we can have a casual kind of in the moment conversation about what moved us, what made us sad, what made us feel inspired. And I'm going to try to bring that all out in the hour that we have with all of these amazing panelists here with me. So I'm just going to start off. Can everyone introduce themselves? So I'll just start by saying I'm Maya Grosz, and I work at NYLAG, and I'm the director of training.
Anna Maria Diamanti. I'm the director of the family and matrimonial practice at Her Justice.
Karla George with Sanctuary for Families. I am deputy director of the Family Law Project in the Bronx.
I'm Shani Ades. I'm the Associate Director of the Domestic Violence Law Unit at NYLAG.
Hi, I'm Hamra Ahmad. I am with Her Justice. I'm the Director of Law and Policy.
Hi, I'm Christine Perumal, and I'm the Director of the Domestic Violence Law Project at Safe Horizon.
Hi, I'm Lisa Vara. I'm the Director of the Matrimonial and Academic Justice Project at Sanctuary for Families.
Okay, so I'm going to throw my first question out to the panel, but I want to start by saying that in some ways, I think this conference, we are poised between acknowledging the devastating and intractable injustices that you all participate in and witness every day, and some incredibly inspiring and beautiful thoughts and suggestions that people have shared with us at this conference. So I want to kind of bring both of those out. So we're going to start first by acknowledging the problems. And what I'd like to do is have each of these folks help to organize one of the panels at the conference. So what I'd like you to do is just name maybe around 3 of the top challenges that your panel identified that you feel are most important for us to work on moving forward. So I think we're going to start and we'll just go down the line. So Anna Maria, start with you.
Sure. So I was on the panel and helped organize one of the panels yesterday on conforming or aligning the law with our current concepts of domestic violence. One thing that really stood out to me was something one of my co-panelists said. Chitra said that the burden should not be on the victim to establish the risk. The burden should be on the evaluator to figure out that risk exists. And as Jen very astutely said, mind blown. You know, we just, as attorneys, as advocates, we don't really think of that perspective. We're so used to coming in saying, I have to prove my case. Like my client has to prove her case. And we never think about flipping it around to say, really, whose responsibility is it to ensure or to determine whether this is a high-risk situation, whether there are lethality indicators, et cetera. And so that was one thing that really kind of stood out to me. Another thing that I think we identified was one issue, again, problem that we have in where our current system is structured, is that there's no real clear direction or indication in the law or in the practice as to when judges, adjudicators, even attorneys, other folks are supposed to do these kind of risk analyses. Is it when someone first comes to court? Is it after a major incident? Is it when children are involved? Is it, some other point in time? Is it supposed to happen multiple times throughout a proceeding? If a case lasts 3 months, does that mean 1 evaluation? If a case lasts 3 years, does that mean 3, et cetera? So building in some concept or some structure for when and how these risk assessments should be done. And I think you asked for 3.
You don't have to give me 3.
I just want to make sure I don't go over.
We can start with 2.
And well, I can add a third in that we have a real problem with a lack of just sensitivity and understanding around these issues in our system as a whole, not just judges, not just adjudicators, but in our system as a whole. Evaluators, police, ACS, everyone, all players involved, including our own profession attorneys. There are a lot of folks who just are not getting it, and we need to figure that out.
I was tasked with organizing the Promoting Judicial Equity from the Bench panel with my co-chair, Christine, down there. And if you watch the panel, they were obviously rock stars and they had us all going, but they did bring out some really important points that I think we need to highlight. And One was a lack of transparency through the judicial process, what happens with the accountability of judges. And I think lack of transparency has just been an issue through all of the panels over this conference. Another thing was the lack of DV training. And I've learned so much from that panel. I did not know myself that all judges are not trained on domestic violence. And that was so interesting to hear. And when our moderator, Judge Ali, said that he has taken on the task of training his civil court judges in the domestic violence training, that just shed a light on what judges do not know. Even though they're very bright and astute, there's still learning that needs to be had and training that needs to be had. And one other point that Judge Bing Newton brought up was retaliation when you are filing a claim against a judge for a microaggression or some type of bias. We did not discuss that before the panel, so obviously that was brought to their attention in some other realms. And so that's an obvious concern for attorneys when even thinking about reporting bias to themselves or clients.
So I had the great pleasure to be able to help coordinate the vicarious trauma panel, which just ended. And I think one of the things that struck me is how imperative it is that we shift our culture where it isn't in right now to recognize how important vicarious trauma is addressed at every single level. Because first of all, if it isn't, then the advocates, we're going to be unwell. It will impact our quality of life. And we're human beings too, who come to this with our full lived experience and experiences, and we need to be cared for and deserve that. But also it means that if we get too crispy around the edges, I forgot what the other word ended up being, but that we're going to leave. And we're all here for a reason. Most people came here from some driving force. And there are communities that we've heard and survivors that we've heard throughout this whole experience that are still getting injustice in the system, even when we're there. And so losing people has real consequences, especially the folks that want to be here. The other thing, I love the idea that was brought up by Dorcas about vicarious trauma being a workplace hazard. And I think one of the main problems I have is that it's not treated as such. It's kind of, we react to it instead of having affirmative acts towards it, putting everybody's gear on. And the last piece is kind of what comes out from all of this, the reality that right now there isn't support. Something that was touched on in so many different panels is this deep need for systemic and structural change in our systems and institutions. And I actually think it's the same thing here. We need systemic and structural change in terms of how we engage with advocates, how we work as a community, and hopefully how we collaborate together to make the changes that we need.
I had the pleasure and honor of the second panel of yesterday morning's day. And even having prepared for the panel, was really impacted by the gravity and the weight and the power of what was shared. And through that, starting with the client voice, the litigant voice, and really challenging how each of those stories are seen as individual stories. It's just that one case, or it was that judge, but really, I think was an opportunity to see this as a thread, as a culture that we need to address, that it isn't just one individual case. And the more that we talk about these individual experiences, we realize it is a systemic problem that these clients have to then face individually. The concept of being receptive to training came out of my panel. Proud to say I wasn't the one who said it, but it was the idea that training is effective and is important and crucial, but is only as effective as those receptive to hearing it and being held accountable for it. And then I would say the third of many things that came out, but is the idea of how and whether and when to bring up issues of microaggressions, how and when to raise safety concerns, hearing about the backlash that it could actually harm you and set you back further in your legal strategy, and the fact that an attorney with their client has to really weigh that decision in the middle of litigation or settlement negotiations is just really unacceptable to have to make that choice.
And I had the privilege of participating as a panelist on the court reform panel, and I'm representing actually Bill Silverman right now, the pro bono partner at Proskauer. So I hope I do a good job. What we talked a little bit about was New York courts, their antiquated system, and how family courts were deeply impacted throughout COVID and how they weren't prepared. And all of the issues we talked about really related back to access to justice issues, right? For our low income Black and Brown families who access the family courts. And what we identified were some top 3 issues was lack of technology, language barriers, more training around technology, and how do we get there? Lack of judges, lack of uniformity. The unified court system is far from being unified, right? And so how do we get there? And lack of accountability. And I guess all of these also go back to a resource issue. And so I guess we'll get into solutions, but those were probably the top 3 or 4 issues that we identified.
And I had the pleasure and privilege of planning the child custody panel in intimate partner violence cases. That was the first panel this morning. And what really struck me was, as you know, one of the largest problems is Joan Meyer's study that she presented first thing in the morning, and how this study really documented many patterns that many of us in this room and online have been seeing in our work. That accusations of alienation as a defense when allegations of domestic violence or child abuse are raised at almost a knee-jerk reaction and can often cause our clients, who are often the primary caregivers and the protective parents, in losing custody, even in cases where the domestic violence is proven and documented. And it seems that courts are more concerned about allegations of alienation as opposed to the actual abusive behavior, or even really common sense factors that should be considered, such as who was the primary caretaker of these children? Does this other parent even know who the pediatrician is? Those concerns seem to not be taken seriously at all anymore. And nobody is questioning what is the effect of forcibly separating children from their primary attachment figure. And the other aspect of this as well is, as Professor Meyer noted, the gendered aspect of this phenomenon, where, you know, in these abuse cases, Allie, our youth survivor, noted that her father was one who was often saying negative things about her mother to her, that her mother didn't care about her, that her mother only cared about her work, but somehow he wasn't accused of alienation. Her mother was one accused of alienation because she and her sister were not, did not want to live with their father as a result of his abusive behavior, which is perfectly natural. I mean, would anyone want to even go out for a meal with somebody who was abusive, let alone live with them? Probably not.
Okay, so now we have the problems on the table, or at least some of the problems. There are more. The most important problems. So now I want to throw out to you, what are several of the solutions that your panel identified, which I know is the harder part, and if you can talk about some concrete next steps.
So we're going to resolve this in 2 minutes.
This panel is going to solve all the problems we've discussed at this conference.
Are we limited to just our own panel?
Do you want to talk about other panels too? I understand that. Yeah.
I mean, there's so much overlap that I feel like I have to. Yeah.
Please,
I mean,
go ahead.
one thing that really struck me from this morning, you know, we heard from an adult, and I love that she basically called herself a survivor of the family court system. That was a fantastic way to phrase it. One thing that struck me was, I wonder how often judges, lawyers, the players involved actually hear from children whose lives they impacted so incredibly. How often do they hear about the results? And so I would love to see a study of children who survived the family court system and hear about their experiences and how they felt about how they were treated. Did they feel heard? Did they feel like the decisions that were made about their lives made sense? Were they good decisions? And present that to the people who make those decisions, and make sure that they get a sense of, here's the actual impact of what you've done. And it's not necessarily to be scolding. It may also be like, there may be examples of, here's when you did something really good and here's why it was so good. But I think that could be really powerful research. And I would love to see a long-term, diverse cross-sectional study like that, and for us to really dive into it, because I think that could be very telling in so many ways. Trying to think if my specific panel identified any particular solutions. I don't know. Yes, we did talk about the possibility of coercive control legislation. I don't know if we came down on a side as far as like what exactly it should look like, but I definitely think there should be some discussion around that, around, again, this idea of, getting away from this model of thinking about domestic violence as an incident-based occurrence. It really is a pattern of behavior, and to really get our systems to think much more broadly than just tell me, time, place, and who the players were and what crime occurred, right? We want to think more broadly about patterns, about controlling behavior, about power and control, and have legislation that really sort of allows us to step back and broaden that focus. Yes, and to include lethality and other risk factors in that. And again, be very clear about when that's supposed to happen. Build in some structure so that judges aren't just sort of left to their own devices, but to really give some guidance as to when and how to do that. And I had one more. Oh, and I just think we talked about resources on our panel as well. We need to increase the resources to family court, to all the courts, really. We need better resources for 18B attorneys, not just better pay is a huge issue, but we know, for those of us at institutional providers, we know the value of, for example, having social workers on staff to help work with our clients. Most 18Bs don't have access to that. So we need to really think about what other resources can we provide to 18Bs to ensure that clients who are represented by 18Bs are still getting high quality representation, that they're not at a disadvantage compared to clients who are lucky enough to get an institutional provider.
So there was a lot of talk outside of the panel because, once again, my panel was pretty robust. And so I encourage you, for the virtual participants, I know space was limited, but being in the room is a large part of this. And so some of the recommendations or what have you that came out of this was about discussion outside of the panel in and of itself. So one of those things is transparency, and that is reforming the court system as far as how judges are elected, all the way to the end to accountability. So I'm sure some of us learned in here today, how do you become a judge? That was not advertised, it's not publicized. We learned there's 3 different ways. And even with that short discussion, I'm sure we're still not sure how to take that path. We still need a class. We might need a packet to review. So let's get that out there so people in this room can become judges. How many times was that stated to us over the last 2 days? So let's get that publicized out there. Also, things that need to be transparent is the court process, and that goes to uniformity, to what Christine said. Once again, I get caught up because that word uniform, I said yesterday, that's my pet peeve, because it needs to be transparent what the rules and regulations are for family court and for each part individually. None of us should have to walk into the room and guess or figure out what we should have prepared, how exhibits are supposed to be submitted, where we are supposed to sit or stand. These things should just be transparent, and we should be prepared to engage in that court appearance. Other things is the training of judges. We know they go through judge school, but what does that look like? None of us know. And then we have to ask that question when we receive bias ourselves. As a Black attorney, I have had the displeasure of having microaggression towards me. And so when I think about that, was this judge trained on that? Even if they were trained in the beginning, Is there continued training? And what does that look like? So we need transparency in that regard. And some of the things that we talked about off the panel with regards to training is the fact that judges are trained for a certain amount of time, but court officers are trained for about 2 months. Judges are trained for about 2 weeks in judge school, about 2 weeks sitting on the bench viewing other cases. How much of a disparity is that? And not to mention the training that we go through as attorneys. How long do you sit with your supervisor? How long did we go through training at our individual organizations in order to do the work that we do? This in and of itself is a training, is an educational experience that we sat here for 2 days and went through. So what does that look like for judges? And one other thing that Judge Bing Newton said is advocate for yourself. So when we think about that retaliation comment that I spoke about a few minutes ago, we can't be afraid. We have to advocate for ourselves and thereby advocate for our clients.
It's interesting because when I'm talking about vicarious trauma, it's like it's so personal in so many ways. But like when you sit here and talk about systemic injustices, I'm just like, but it's kind of the same thing. And so I think when I think about vicarious trauma, one thing that I know a lot of the panel members brought up is this idea of individualism and collectivism. And the first thing I'd like to say is that we all have to like look at ourselves and give like a hard look at our agencies and ourselves as we're a supervisor or ourselves if we're an advocate engaging in this and seeing like, how are we doing? Like really, how are we doing? And think about, I love the idea of being receptive to training. I think training has to be receptive and repetitive. Like it's great to get a vicarious trauma training when you onboard somewhere so you know from the start, hey, look out for this stuff. But are you re-getting that training when you're starting to experience some stuff too? And so for me, I think it's really important that everybody look at themselves, look at their own organizations in the mirror, and then collaborate. The thing for vicarious trauma for me is there's no model that works for everybody. In the beginning of the pandemic, I myself, whenever I was on these Zoom calls, people were like, everybody introduce yourself and say what you did for self-care this weekend or what you're going to do this weekend. I was just like, I'm going to do nothing. That is my self-care sometimes. And that's okay. Maybe doing nothing shouldn't always be my self-care, but sometimes it's okay. And I think that point that like what self-care is for every single person is different. And it might be different even for that person in different moments. And so if we are talking to other organizations who are all hopefully in this room caring about this, because at least the people from them here care, then we can think about like, well, what are you doing that's good? Let's learn from each other. Let's share ideas. Let's provide more support, because I don't think you can do this work without community. And I think that the community that can be found is broader than just who you work with, although hopefully it gets instilled there too. I think the community that we can find from each other can help us bring meaning to our work, help us feel supported, and also help us push ourselves to have momentum, to kind of put into place better practices to make sure that everybody that's doing this work feels as supported and inspired as they did when their eyes were huge that very first day, like rushing into the room.
Totally agree. And I think echo some of what has already been said. So hopefully that makes the action plan a little easier. But so back to training, not only having transparent accountability of not just the process, but what happens as a result of the process, but creating a metric or evaluation or some tool of measurement of progress. Like, what is the impact of the training and what is the effectiveness? And it shouldn't wait until the negative impacts, right, of someone's seemingly lack of training or sensitivity on a topic in order for it to take action. Secondly, I think resources, we can't say that enough. We've all acknowledged that the court system is greatly under-resourced, and in order to make some of these changes needs more support, which goes into the third piece that we talked about of like legislative fixes. So there is legislation like Cura's law, excuse me 1 second. And and other laws that will improve our way of looking at what are the standards for the best interests of the child, what should or should not be considered. The fact that we have to legislate these things will also require resources to implement, and then again hold people accountable, and have transparent systems where we can measure that.
I guess I'm going to echo a lot of what everyone else said regarding resources, accountability, transparency. But one thing that was mentioned on the court reform panel was court simplification and court reform. We didn't get too far with that, right? And so we need to revisit that. And I think that it's not going to be perfect, right? The bill is not going to be perfect, but we have to start somewhere. And we may not agree on all points, but this really boils down to a resources issue. And we looked at the chart that Denise had up, and we saw how incredibly complex our court system is compared to every other state in the country. And so it made sense when she boiled it down, right? Oh, wow, this is a great picture. This really solves or could help solve our resource issue. And then in turn, we have to work from there, right? So it's really just starting from there and then building upon that. We talked about accountability, and I know that Her Justice had a wonderful court watch program as it related to child support. Maybe we need to go back into that and look at ways that we can do court watch programs in our family offense and CBO parts. And so that's something that we should come together and explore. And then we also talked about language barriers and how can we do better at that? How can we just, provide information to litigants in more than just 2 languages? And so I think that, thinking about ways to just, it always gets to me that New York City is an incredibly diverse place, right? We have boroughs that are arguably the most diverse places in the world, and yet we cannot provide language in more than 2 languages, right? So we only have English and Spanish that we're able to provide documentation to litigants in. And so maybe conducting surveys in each borough to see what the top 5 languages are and providing some translation of documents in those languages. I mean, just thinking a bit outside of the box. I know that Lisa Alexander talks about this too. And so I think we need to really explore those options. And I think there were just so many points, but those were like the top 3 that came out of the panel.
So with our panel, I think a common theme that many panelists brought up was, treating custody cases like a 50-50 math problem, where the abusive parent who may not have been very involved in the child's life up until that point is insisting on having 50% custody. And if there's any view of resistance in any way, there's an accusation of alienation, which may also be repackaged in different ways. The word alienation may not necessarily be used. It may be said as friendly parent or manipulation, but really listen to children, give children a voice, listen to victims. Another statistic that Joan Myers cited in her study is that, only 1 out of 51 cases of child sexual abuse were credited. And we know statistically that can't be right. Statistically, at least 50% to 73% of these cases are generally verifiable. So to think that only 1 out of 51 cases has the protective parent, often the mother, telling the truth can't be correct. And that goes into training as well. Judges I have been saying for a very long time that judges need to receive this training on domestic violence that some specialized judges receive. It didn't seem apparent whether every judge was, and I'm glad to hear that that it appears that they will be receiving the training or should be receiving it, but they need to be held accountable for their decisions. We can train all we want, but if they're not receptive to it, and if they're not held accountable, that only goes so far.
Okay, so we have some extra time. So I have my final question for you, but I'm going to insert a question that I did not tell you about before, but I think you can handle it. You mentioned a minute ago that that somebody said something on one of these panels and it went like, whew, like mind blowing. Okay, and I feel like there were a few of those for me. So I wanted to just and this does not have to be in order. What were some of those moments for you all? Now you're off your own panel. It can be from any moment throughout the conference. What were some of those moments that for you, where somebody said something you hadn't thought of, made a connection that you hadn't connected, or you just learned something new, or something surprised you? I did not give them this question in advance. So if you need a moment to go, okay, what was that?
Out of order.
I'll start with Allie and her story. I actually had to leave the room, and I'll just be personal for a moment and talk about the vicarious trauma that came with that story. I saw a colleague outside of the conference room when I stepped out, and I said, I don't know if me stepping out, I felt like I wasn't strong enough to hear that. And to me, that I had to look at myself and say, is this vicarious trauma? Did I need to step out the room? Did I show that I was weak in stepping out the room because I couldn't listen to that? And so that was a wow moment for myself, in that all of the years that I've been practicing, it doesn't stop. You still need to step outside the room, and you need to take that space for yourself. And just in the substance that she discussed, I practiced in New York, in New Jersey at one point, but the fact that there was no AFC to give her a voice in the court, and that's happening in other states, and these camps that are like in hotels, I can't even tell you. So that was a mind-blowing moment for me.
I think for me, it was Smith's comment about boat builders and engaging with other boat builders. And you may only be able to help 50 people, but somebody else could help 75, somebody else could help 200. And that's how you do it. That resonated with me because I found out that over 750 people from across the country had registered for this. And I said, well, if we get the word out, if other people are seeing these same patterns across the country as well, maybe in fact we can effectuate change if we feel like that we as individuals are not able to.
I'd have to agree with Karla and Lisa. I don't know how you couldn't be touched by Ali's story, and just, I'm also, I'll get a little personal. I'm also a product of the family court system, and I was in family court as a child. And so hearing her story and just how she overcame that was, it resonated with me, because this is why I do this work as well. And Hawthorne's comments with the boat building also affected me too. And you have to give yourself grace and patience to do this work. And so there were moments in the conference that you had to take a step back, but I think that's okay, to allow yourself to take those few steps back in order to do this work.
Okay, as a moderator, I'm going to share two for me. Joan Myers, the last piece of the research that she talked about when she talked about psychological denial and vicarious trauma for judges, for me, I was like, oh my God. That to me explains so much of the frustration that I hear you all speak about when you're talking about the judges. And I just suggest that thinking about why judges are so insensitive and understanding that through a lens of vicarious trauma, to me, just changes how we talk to judges about moving through that. And then just connecting that to the most recent panel on vicarious trauma, I just personally also started like having all these flashing things in my mind about different people in my life who are in caring professions. And it just explains so many things about their behavior and my own. So brilliant.
I'll go next just because mine's connected to that, which is anybody that knows me knows I'm not a naively optimistic person. I like to call myself a pragmatist who like weirdly has optimistic streaks. And one of my optimistic streaks is that I always try to err on the side of compassion. And our system is incredibly broken. But one thing that resonated for me yesterday was Stephanie's incredibly powerful speech and this concept of that came out in other panels too, of making the invisible visible to people. You can blame people, and we should. They carry some guilt sometimes for having whole swaths of cultures and communities and lived experiences be invisible to them. We can. We can also try to err on the side of compassion and say, I hold that as true. That it is super problematic that people in positions of power are not understanding or attempting to understand and learn about the people and the true people that are appearing before them. And we can hold that as true and also say, and what if they did know? And what if we can kind of present to them in some persuasive conversation and err on the side of compassion with, I also don't know this person's lived experience. Maybe they seem super defensive and not understanding because they're having their own trauma reaction to something. I remember, I'm not going to be too specific and I'll be very quick with this, but there were a couple, so this won't be obvious, but somebody who is no longer on the bench, don't worry, many moons ago, was pretty notorious in their court part for always yelling. When you went into the room, you would prep yourself, your colleagues, and your clients. This person is going to yell. Literally isn't about you. That is their mode of communication. Super troubling, super problematic. Nothing I can do about it. This will be our experience. And one day I had this one very specific case that had a fact pattern that was a little bit unusual. And I don't want to share it only because I feel like then I might uncover some details, but the jurist pulled me up and shared an experience of when they were an attorney and they lost a client with this exact fact pattern. And it was a light bulb moment for me. And I don't forgive the experience that she gave countless people in actual need walking into her courtroom and being screamed at. I don't forgive that of her. But it did give me some compassion for like, whoa, maybe this person shouldn't be here anymore. Maybe this person needs support. Maybe this person needs like a ton of training and therapy. But like, there's actually like something behind this I wouldn't have conceived. And it doesn't mean, again, necessarily like forgiving or saying it's okay, but it might help us, if we figure out those answers, help people be more receptive to change as well as training.
All right. Our final question, which is related to what we just said. What did you hear? It could be from your panel or at this conference that inspires you to believe that we as a community of 750 people who are online and attended this conference can work together to achieve the changes that you know and believe need to happen.
Well, I had a reaction. I was talking about with my colleagues that for those of us who've been in the field for like 20 plus years, there's been such progress and also such moments that it gets so bad you become cynical. And so there's finally some recognition about that DV exists and these are the patterns this happens. And then the huge wave of backlash, which we've talked about, right? We don't believe victims. We don't believe that this happens, become cynical. We internalize it as practitioners. And then maybe it's this coping mechanism or psychological denial or vicarious trauma where even with our clients, where is the abuse bad enough or that's not going to fly in court? And it becomes so negative and heavy. And to be honest, this conference and all of the conversations that we've been having, I feel is a backlash to the backlash. Like, I feel like this is an opportunity. I mean, to 700 people, the conversations we're having, the opportunity to collaborate and to come together is inspiring in and of itself. So I see so many different points of light, not to reuse that term, but opportunities to kind of just expand and enhance.
All of you have to answer this question.
Oh, really?
Yep. All of you have to answer.
One thing that struck me, I was thinking when Judge Bing Newton was saying, don't let the fear of retaliation stop you from, reporting a bad judge. What went through my mind was, that's not it. I'm not afraid of retaliation. I mean, I am, but not like, that's not always the thing that might stop me. What I'm afraid of sometimes is, okay, if I report a judge who maybe did something inappropriate, okay, maybe I'll get rid of that judge. But what is that? Who's that judge going to be replaced with? It might be worse. So that's
For those of you online, we just got a yes from the audience.
And honestly, that's actually stopped me when I've had situations where a judge, is notorious for screaming or just doing something inappropriate. But at the end of the day, I'm like, yeah, but I'll still get the order of protection and I'll still get the custody order. So just let it go and deal with it, because it's not worth risking getting an even worse jurist to replace them. So one thing that inspires me, though, is that if we can make real reform in our system, if we can improve the process for selecting and training and holding judges accountable, we know we would no longer have to put up with ridiculous screaming, inappropriate behavior for the sake of, at the end of the day, okay, you'll if you put up with this nonsense, you'll get what you need at the end. And I really look forward to that. Like, I look forward to this idea of we don't have to keep settling for less than. We can actually collectively create a system where, we deserve better, so we will get better.
This is going to sound negative at the start. I don't know how you don't walk away from the concept that the Jay Johnson report just repeated what was said back at them and however many decades ago about, and things haven't moved forward from there in a significant, impactful way, and not come away and have our experiences engaging with the system and not come away with this concept of yeah, the system's totally broken, right? In so many ways it is broken. And maybe that's a good thing. Maybe when things are so broken that you're having these realizations that you're just overwhelmed by how horrible it is, that we have the capacity to think bigger and to say, I don't care if it's not practical and you don't have the resources for this right now. You have to figure this out, and this is why. And obviously, there's a million steps along the way where you hopefully get more practical to make it implementable. But I do think that there is, in moments of real despair, the moments when you have the most momentum and possibility for change. And I hope that we kind of take advantage of that versus just have another report a couple decades from now.
I have to admit that it is a bit discouraging to hear that the Jay Johnson report was exactly the report that they had 20, 30 years ago. And we haven't moved the needle that much. That is discouraging. And the conversations that we've had over the past 2 days are difficult and they're hard. And you kind of walk away with okay, we're never going to fix this. This is incredibly broken. But then you kind of step back and you think that there were over 700 people who registered for this. And there's a huge community out there who cares about these issues. It's not just the organizers and the sponsors and the co-sponsors. There is a huge community out there who cares deeply about this work. And I think that in itself is very encouraging. And there are already other nonprofits. I'll plug the Fund for Modern Courts, who's doing incredible work for the court reform panel. And we should collaborate. We need to do more collaboration. And we have done that over the past 10 months with Jennifer Friedman's help in organizing this and getting to this point. And I think that there's momentum, and that is very encouraging.
Agreed. This really goes back to Hawthorne Smith's point about collaborating with other boat makers. This is exactly that point. Over 700 people registered for this. They may be in touch with other people who weren't able to register for it or weren't able to be here for whatever reason. This can get spread far and wide. There were people from other states who registered for this. These are not issues that are unique to New York at all, by any means. And yes, I mean, we can get more involved in suggesting different trainings or vetting candidates who are judicial candidates who are going to be receptive to trainings, getting the right people in place. Training, even Kira's law, which was not something that my panel specifically touched on, but it's there in the background that, common sense measures to prioritize protecting children over everything else. And, hopefully it's been through various stages of drafting and it's been introduced, and, we may be able to see that become law one day soon.
Yes. Yes, hopefully next year. And I as far as my inspiration, I'll refer back to Stephanie McGraw, where she said, when you're pointing the finger at you, you have three pointing back at yourself. So what are you going to do? And that's what I'm taking away from this. There's more work to be done, and I'm not ready to give up. And so I'm going to challenge myself every day to do something better, to do something more, to get more involved in policy work, to help CARES law pass, to do these things. And going to something that Hawthorne said, you're not going to find the time, you're going to have to create it. And so taking away from this, my inspiration is looking back at myself and saying, how can I be more powerful? How can I be more impactful? And how can I find the time to create that space so that I can do these things? And I know I can, and I know all of you can, and all of the 700 people that registered can do that as well.
Okay, those were awesome words. Those might be our closing words. I don't know. We have a few more minutes. I am going to have to just announce the CLE code, which is just very down to earth compared to what she just said. It is 6573, and I'm supposed to say it again. 6573 is the CLE word. We do have a couple more minutes. Is it okay if I take comments from the audience?
Actually, we haven't done this at all.
You want to do it?
We have been totally fascist in the way that we have organized this. And I can point that finger at myself, whatever that thing was, because I literally just got it, Karla. These three fingers are pointing back. It's now, she said it like 4 times yesterday, but thank you for, I mean, maybe we can take a few minutes for either questions or let's keep it positive, or any ways that you were inspired. And I will walk around with the mic. Oh, Dorchen is either has a question or is inspired. Let's find out. Here.
Wow, this is amazing, the power of the mic. No, I am totally inspired and moved. And this has been the most incredible conference. And just when you think about who has been brought together to address these longstanding intractable problems. But one thing I've been thinking about, very much connected with the vicarious trauma panel, which was so fantastic, Lisa, was I think about the comment that in your opening remarks, you talked about the way one judge responded to your client. And I don't remember all of the details, but I do remember that judge just sort of lambasting her in court. And I think of Jacqueline, and this is not because there were so many wonderful judges and we've had so many wonderful judges participating in this conference, but the judge who told Jacqueline, when she was articulating her well-founded fears of danger to her daughter, you better grow up. And that's a theme. You know, I've had those experiences myself. Someone mentioned Judge Judy. I appeared before Judge Judy, not Judge Judith Harris Kluger, who's the most amazing judge, but and my boss, but Judge Judy, who, you know, that's how she behaves. And what can we do? And Charlotte and I were talking about this because there are vicarious trauma issues with our judges, and you know, judicial temperament is an ethical obligation, and we are not seeing that. What can we do to make the courts less traumatic environments for survivors and their counsel? What kind of training would really make a difference? What kind of measures of accountability would make a difference? But I think that should be a priority. It doesn't have to be so bad. Survivors don't have to be treated in such abusive ways. We recognize those problems for prosecutors, and we have FETI training that really is a deep dive into trauma for prosecutors. Can we do something comparable for the judiciary? Perhaps that can be part of the recommendations.
Thank you, Dorchen. And since you're my supervisor and mentor still after 20 something years of practice, I'm like, I don't know, Dorchen, what do we do? You don't know the answer. Oh my God, where are we? But I hope made some, part of what was really beautiful about the process of putting this conference together is how many really prominent and influential people actually came and spoke and engaged with us and truly care. And so maybe some of those questions can be posed also to them. And we invited their voices in the room. And we were actually a little afraid that they might not want to come into the room with us because we knew we were going to have pretty outspoken advocates. And I did have to say to some of these judges, there will be survivors telling their stories. There will be advocates holding your feet to the fire, but we really do invite you. And they did come, and I really value and appreciate that. So hopefully we can get somewhere with them.
Can I say
Angela?
one quick thing also? Is that something that made me think of was earlier today, there was the talk on the judicial equity panel about how judges become judges. And I'm actually on the Judiciary Committee for the New York Women's Bar Association, and the Bronx Women's Bar Association was here today. And let me just tell you, like, the people that do the judicial screenings for people that are running to be elected and want support to show that they're qualified, right? It's filled with people from the private bar. And I'm just saying that, like, we have 700 people here, guys. Let's all start to have some like real nonprofit community organizations present when judges are being vetted by the bar associations, or when we know that there's problems with judges that specifically with temperament or not understanding trauma, which is so essential. They have training on trauma. Let's send letters with examples to the mayor's office when those 10 years are up, and let's not forget about it.
So there were so many things that were mind-blowing to me throughout the 2 days, but I used to practice here in New York, and I left a few years ago, and now I'm in Fairfax, Virginia. And there's problems with the courts there as well. And one thing that we did in Fairfax that I think was incredibly helpful was we did a systems walkthrough. It was a collaboration between judges, victim services providers, survivors, and we had a consultant from OVW. Actually, it took a couple of months, but everybody was committed because we wanted to see how victims operate and navigate their way in the court system. And it was an opportunity for the judges to see what's happening when a victim first walks in till the end of their hearing. And it was so enlightening because it gave them an opportunity to actually see firsthand what our clients go through. We were able to identify gaps and come up with real solutions to address these gaps. And so having a more collaborative and a coordinated community response has done wonders for Fairfax County. There's still a lot more work to be done, but in terms of looking at issues with language access, looking at issues in terms of like the entire process, the protective order process, and trying to get a protective order, and you know the notion that people not only understand English, but they're able to read and write, and just being sensitive. There were so many things that came out of that systems walkthrough that I think for not just judges, but even as practitioners was really eye-opening for us. So that as I'm sitting here and listening to, you know, us trying to come up with creative solutions to help improve the system, I think incorporating the voices of survivors in ways that will resonate with the judges is an opportunity for us to make some real change.
I just want to jump in. I would love to send some judges to HRA to apply for food stamps or try to get housing through NYSHA. Good luck. Good luck. I just really quickly, I had the experience once of appearing in front of a judge. Yeah, all of it. Send them all. Send them all. Appearing in front of a judge who had just changed custody of one of the children. So the children were split, and did not believe us that our client was going to have to leave her shelter residence because the number of children were reduced. She literally called the shelter and demanded that the director get on the phone with her on the record to confirm this, and talk about mind blown when she heard that, yes, that's in fact the case. Mind blown. She had no idea how the system worked, and she was stunned. So I would love this idea of let's do some walkthroughs so they really see what life is like for our clients.
Okay, so we have about 2 minutes left, and a few people want to say things. So quick.
So to bounce off what Angela said, there was once a great advocate named Ellen Pence. She's passed on now, but she created the safety audit, and it was for law enforcement, but it was very much that. It was very structured. and they all looked, you know, it was very neutral, but they looked at the processes, the paper, everything that, you know, the way documents were kept, and that changed practice. And they could change it because it wasn't like, Angela, you're doing that wrong. You know, it was together, you figured out a better way. The other thing is the resources. And when you talk about family court resources, I think it's important not to just think about the numbers of judges and that sort of thing, but to also think about children's centers. In 2008 and 11, when the economy collapsed, they started closing children's centers. They didn't reopen all of them. Children's centers are very important, as I don't have to tell you, for, you know, litigants trying to come into court. So advocate for that as well. Every courthouse ought to have a children's center where you can leave your children while you're in a court proceeding. And in addition to children's centers, we need supervised visitation. And these kinds of resources that the people we're serving need to be able to participate in their case need a lot of advocacy, because it's about money. And they say, oh, there's not enough money. We're talking about just a few $1 million. The state's got billions of dollars. The other thing is to do with training for how to become a judge. The Franklin Williams Commission that's been mentioned here many times, they go all over the state and they do a training how to become a judge. So maybe sponsor a training with them and you know see what they do. There were some other things, but I can't remember them right now.
You know where to find me, Charlotte. So that's okay. So this is lightning round. I see one hand, and then Jacqueline, I'm going to give you the last word.
I think, you know, COVID's changed a lot, and what I miss pre-COVID, amongst many things as a supervisor, is training new advocates is incredibly hard during the post-COVID world. You know, I think it was someone on the vicarious trauma panel mentioned how, like, we sit in our rooms now and eat lunch alone because, you know, it started with 6 feet away, and that's just become ingrained as part of, like, our work culture. And that is it's really hard to connect via a computer screen. And I think as things reopen, we have to really think about how we're going to really try to physically reconnect with each other to provide support for each other. But in addition to that, you know, also the court system, how, you know, I have litigators who've never litigated a case in person, and they don't benefit from sitting in the back of the courtroom as one of the judges. I think it was actually Michael who mentioned it, like seeing the judge, what they rule on cases coming before them, what triggers them, what do they, you know, hone in on. Those are all lost. And I think that we have to be kind of thoughtful about what is this next generation of litigants experiencing, what is the next generation of practitioners experiencing. And it's not the way we were trained. And there's a huge disconnect in supervision now because we weren't brought up in the same experience, and trying to bridge that, I think, is something we have to really think about.
Thank you. I think we've all experienced this. This is a big frustration, training staff. Okay, Jacqueline, I'm giving you the last word. Actually, I'm giving myself the last word.
That's pretty fair. That's pretty fair. First, I just wanted to say thank you to everyone who's here and everyone who's in the Zoomiverse watching this. And, you know, in terms of just being inspired, you know, even though I've seen the horrors inside of the family court system, and all of you have as well, you know, to see you each day get up and fight and battle and do all of this, just thank you, because we wouldn't know where to turn without you. So thank you so much. Also, what happens here, I hope doesn't stay here. I hope that we carry this forward in many, many ways. And, you know, I was stepped out of the room for just a few moments today. We are going to have a lobby date for Kira's Law on January 18th up in Albany. And I would love to have all of you come, by the way. January 18th. And I'll be making a major announcement about that, but we just found that out, just got it confirmed today. But there's also things like the Downstate Coalition and other ways we need to carry these conversations forward and get the voice out in so many more different ways. And Jennifer, thank you for putting together this incredible conference to get these conversations going and, you know, help them speed ahead in so many different ways.
Thank you, Jacqueline. You're so inspiring to all of us, really. So I guess we are at the end. I have a few closing thoughts. First of all, I might actually cry, like, because this, and Barbara Kushko is also on the roundtable, but I think other than that, this might be the whole actual roundtable. Who else? Oh, and Rachel, come up here for a second. Seriously, these are the folks who put,
And Jennifer.
Jennifer Berry.
Oh, and Jennifer Berry, come over. This is the group. Seriously, come up. I'm not kidding. Actually, physically get out of your chair and come over here. And Rachel and Barbara. So this is the group that put together this conference. And and when I said that we had 10 facilitated conversations, actually Maya was our facilitator. And I'm going to try not to cry, but I am so amazingly inspired by all of you. This process was a very long process. It was actually like a support group. It was actually really cathartic when we would meet together and kind of talk about all the problems. And we're like, oh my God, like, yes, it was like consciousness raising. These are real. This is not just in my head. I had that experience in court too, et cetera. And so we want this to continue forward. As I really got to know all of these women amazingly well and have just the profound, deepest respect, seriously, for all that you do and all that you are, and for your staffs and your organizations, because we are all in this together. I know sometimes our organizations operate kind of in silos, but I mean, we really do all stand with each other and for the same outcomes and want all the same things. So this was a great kind of, I don't want to say post-COVID, but a coming out of COVID thing where we could get back together with all of you who might still be there online. Maybe you're not. I don't know. It's Friday afternoon, but who knows? But our goal, and several people said that they felt that the conference was well constructed, and we really appreciate that, because we spent a lot of time talking about how can we make this not just like, let's all get together and talk and move on. And we built this last session for the purpose of this is our advocacy agenda. This is what we want to do going forward. Using HOVA as the beginning of that, we are actually going to send an email out early next week with a survey saying, here's the issues we talked about. Which of these are you interested in? Please sign up. So that will go out to everyone who signed up on HOVA. I hope that means you in the room and you online. And I hope we can continue. I don't know exactly what form that's going to take. And we, deeply value our already existing organizations like LCADV, in which we do already get together. And so we need to think about the various, we have a really aspirational list. We have a list of really important advocacy priorities and how we're going to move those forward. But this is definitely not the end. This is the beginning. So thank you all for being here. I am so inspired by this group, and I hope you are too. Thank you.
I'm sorry, Jennifer, I just have to jump in. This was very much a group effort, and I very much appreciate this entire group, but it was very much a Jennifer-led group effort. So can we just
Jennifer-led? She means Jennifer Friedman and Jennifer Berry, who are next to each other, who did this whole thing.